Welcome to the topic of immigration, navigating a complex system, and how to keep women safe. Women who are leaving an abusive relationship have to be prepared to embark through a number of systems, and the process can become quite complicated. We have the criminal justice system that becomes involved if there are charges laid, victim services to assist the woman, the family court system if there's divorce or children custody matters, and potentially the Ministry of Children and Families if there's concerns with respect to the children. So there's a number of systems that a woman would have to be prepared to navigate through. When the woman is an immigrant woman or dealing with immigration, the navigation process becomes even more complicated. It's for the most part, in immigration, we see the systems working within their own silos. And as a result of this, there's a number of scenarios that can arise in the immigration context that we need to be vigilant about in order to keep women safe while they navigate the system. A few years back, there was a project funded by the Law Foundation involving EVA BC, Mosaic, and the Family Services Organization in Vancouver. And it was a 3-year project which took a look at immigrant women and domestic violence and the situations that they were facing. And the project involved a number of focus groups that were held throughout the province of British Columbia. And as a result of these focus groups, it became evident that there were some common themes that were emerging that needed to be addressed for, again, immigrant women who are facing domestic violence. One of them is sponsorship debt, and one is out-of-status women. And one that's come up since the project is the conditional permanent residence category. So I'm going to touch upon these issues. The sponsorship debt, this is pertaining to a scenario involving a woman who has sponsored a spouse from abroad. The spouse comes into Canada and abuses her. She is then in the situation of deciding whether she should leave that abusive relationship. And I've had a number of women come to my office saying that they are afraid to do so because they have signed an undertaking with the government that they're going to provide food and shelter for the person they sponsored, and that if they leave the abusive relationship, they're afraid the spouse will go on welfare and that they will be pursued for this. So just a bit about the undertaking. The undertaking that a sponsor signs is a contractual obligation to repay any monies in the form of social assistance to the sponsored person. And so that's what these women are afraid of. And in fact, some of the women that have come in to see me have said that their spouse has indicated that they will in fact go on welfare and work under the table just to cause further distress to the woman. Now, with this undertaking, what's unique about it is that it is an undertaking given to the federal government for 3 years by the sponsor. It used to be 10 years, and with women's advocacy, it was reduced to 3 years. But the unique nature of this undertaking is that while it's an agreement signed with the federal government, it is actually assigned to the provinces, and the provinces are the ones that would collect if any monies were paid out. And even it doesn't matter what the circumstances are, even if there is abuse, what the paperwork says, the undertaking says is that in those cases, collection may be held off if the default is a result of abuse, but resumed once circumstances have changed. So again, this becomes a deterrent for women to want to leave these relationships because they're quite fearful that they're going to have this huge debt that they'll have to repay back. And again, it's a 3-year undertaking right now, and for family class, which is parents, grandparents, sponsorship of those persons, the undertaking is actually now 20 years, so quite a lengthy duration. But for spouses, it is 3 years, and again, many spouses that are facing abuse when they've sponsored a spouse are choosing to remain in the abusive relationship. So they would rather remain in the relationship than incur a sponsorship debt. And as stated, the abusive partner may deliberately incur the debt. So how do we help women navigate this issue? When I have seen women come to me in this scenario, of course, safety is what I advise them, that their safety, the safety of the children, is the most important step that they need to be concerned about. But it's easier said than done when they're living with the possibility of their spouse incurring this debt and being contractually then obliged to repay it. There was a case that went to the Supreme Court of Canada a few years ago, the Mavi case. And through Eva BC tried to gain intervenor status into this case. This is a case which was a collection of cases come together as one pertaining to the sponsorship debt. And essentially there were various scenarios of people who had sponsored someone and that person coming into Canada, either in the spousal context, leaving them and incurring the sponsorship debt, so using them just to come in the country, what is known as passport marriages or fraudulent marriages. And other scenarios were people who had sponsored parents who had come to the country and the parents got quite sick and they're not able to take care of them, and they don't have the financial means, or the circumstances of the sponsor have simply changed and they've lost a job, or they themselves are sick and are not able to pay the sponsorship debts, so the person they sponsored went on welfare. So the lawyers representing these various cases were arguing that the government should have the ability to not collect on these debts in these circumstances. The Supreme Court of Canada reviewed the law at length in this area, the legislative provisions, and said that this is a statutorily created debt and it has to be collected. But so at first blush it seems as if though the decision is not recognizing the difficulties that people can face as a sponsor. But the Supreme Court of Canada also says a number of things which can be used by advocates to assist sponsors facing the sponsorship debt. For example, the Supreme Court of Canada did state that short of a write-off, the province, in fact, does have discretion in how it collects its monies. And it provided an example of if there's a fairly large sum of money owing, the province could agree to perhaps $20 a month, which is a small amount and may take forever to pay off, but the province certainly had the discretion to do that. And also the Supreme Court of Canada said that in some instances the province needs to recognize that it may not be in the public interest to collect. So I take these two pieces of nuggets, I would call them, from the decision, and I try to use them in cases where women have come to me. For example, I have advocated for a $1 consideration to write off the debt, so that's being short of write-off, saying that the province does have the discretion to do that. And I have advocated that it's not in the public interest to be collecting from abused women, that in fact that such a process is re-victimizing the woman. My first line of argument has not been successful yet, suggesting that they take $1, but myself and Eva BC currently are in dialogue with the province, the Provincial Office of Domestic Violence, with respect to this issue, and we're hopeful that there may be some regulation change or policy change with respect to collection from abused women, and that collection hopefully does not take place. Until then, the recommendation is in helping women navigate this issue is to use the favorable points from Mavi to emphasize that the province has discretion and it's not in the public interest to collect from women who are abused. Another area where immigrant women, are facing some hurdles is this new category of conditional permanent resident. It actually arose a few years ago, and it was a category created to address the issue of fraudulent passport marriages, something that I mentioned just previously, where people are just marrying to come into the country. So I believe it was in 2012, October, that the government introduced conditional permanent resident category. And what that means is that spouses or partners being sponsored to Canada in a relationship of 2 years or less with no children will be subject to conditional permanent resident status. They have the same rights as a permanent resident, but the condition is that they must live together with the sponsor in a quote-unquote legitimate relationship from the day they receive conditional permanent residence, and the condition ends after the 2 years period. And again, as stated, the category arose to address the issue of fraudulent marriages and the government wanting to ensure that only those in genuine relationships were allowed in Canada. So what happens to a woman who is sponsored by her spouse in Canada, and after she arrives, she's subjected to abuse during that 2-year period? Is she required to stay in the relationship for the 2 years? And how do we help such a woman navigate the system? As part of dialogues that were taking place before this conditional permanent resident category was formally put into place, there were discussions with groups from the anti-violence sector. Myself and Eva BC were called to give our opinion and feedback on this condition, and we did raise that we were concerned that women would stay in the abusive relationship, that even before this conditional permanent resident category, and when we had done our focus groups, another strong message that came out was that women who were being sponsored into the country were told by their sponsor that the sponsor had control over their status in Canada and could have them removed at any time. And that was, of course, a myth because they were permanent residents. But now with this actual category of conditional permanent resident, we made submissions saying that this is going to be putting some teeth to what the sponsor has been saying before, that they are in a position to remove them. But we were assured that there would be a system in place that a woman facing abuse can request an exception to this condition. And there's actually a CIBC backgrounder which specifically states that such women can come forward without having to worry about enforcement action. And there's a number in the backgrounder that they can call to request the exception. And it's in this slide 1-888-242-2100. So apparently they were going to provide training for staff, so when women did call, they would be assisted in getting out of the abusive relationship. And I just paused to add that I recently had a client come to me in one of these scenarios where she was in that 2-year window and going through an abusive relationship. And when we tried to call the number, it went through a number of different prompts: press this button, and it was a message at the end saying that we're not this basically system overload, and we're not able to take your call right now. Leave your number. And then someone eventually emailed my client with an officer's name to speak to, but it wasn't the easiest process. It wasn't what we had envisioned, that there would be someone live on the other end, willing to and ready to help these women. It was much more difficult to get someone to actually speak to. So we can imagine a woman who finally gets to the phone, finally finds this number, if she's having to essentially get a bit of a runaround until she's able to speak to someone again, she's going to be deterred or unlikely to continue to want to even try and navigate out of this process. But let's say the woman is able to get through the numbers, gets to an officer. What are the type of considerations that are made when a request for an exception is made? And if we look at the CIC backgrounder, there, there's actually quite a comprehensive definition of abuse. It's not just physical abuse, which is defined as assault, forcible confinement. It's also sexual abuse and sexual contact without consent, psychological abuse, including threats and intimidation, financial abuse, including fraud and extortion, neglect, the failure to provide the necessities of life, food, clothing, medical care, shelter, any other omission that results in a risk of serious harm. The backgrounder also states that there may be a number of reasons why victims may not abuse to authorities, such as being alone and isolated, being provided false information about their status, language barriers, religious, cultural constraints. And so, in my opinion, the backgrounder, which is in OB 480, an operational guide, is actually quite comprehensive in reviewing what may be considered to be abuse, and also in quite liberal in its understanding of who could be abusing the sponsored party. It could be not just the spouse, it could be in-laws, other family living in the house. It could be the sponsor's children or other immediate family that are being abused. So it's quite a broad and liberal definition that's in the operational guideline. But what I've recently experienced myself is that the system is not as easy to use or user-friendly as I had anticipated it to be. Like I said, there is a number, but it took a bit of doing to get to an officer. And in this one particular case, we had sent submissions off in April of 2016, and we still are awaiting any sort of acknowledgement or response. So it really doesn't give women who are trying to leave the scenario of abuse in that 2-year window a lot of confidence. Mind you, I have heard of one instance where someone walked to an actual immigration office and was granted the exception right there. So there may be those rare situations, but my own personal experience has been not too optimistic. And the other troubling features of this are is if the exception is not granted, what then? Is the woman expected to go back to the spouse and live with him after doing these submissions, or is some sort of immigration proceeding going to be commenced, and then she'll have to go through the appeal level to the IAD and argue compassionate grounds? It's not very clear, but the positive thing that we've heard with the Liberal government coming into power is that the conditional permanent resident category is going to be revoked. We're waiting to find out more details. That hasn't happened yet, and waiting to learn whether that will be retroactive. Because in my own personal opinion, the category is doing more damage than good, and that people who are going to commit fraudulent acts, which is what this was meant to deter this category, are going to do it no matter what. I've helped women who've sponsored a spouse where the sponsorship was denied, and we appealed it, and the appeal took several years, 2 to 3 years. During that time, their spouse abroad was very nice, very giving them the red carpet treatment whenever they would come visit, but as soon as that spouse entered Canada, they left him. So a person who's going to be fraudulent, in my opinion, is going to do that even in Canada. They'll feign being in a legitimate relationship for 2 years if that's what it takes. So I'm hopeful that this category, removal of this category, will be retroactive. The other category where we found in our focus groups immigrant women were experiencing a lot of challenges leaving an abusive relationship were out-of-status women. And so these are women that may have initially had status when they entered Canada and then subsequently lost it, or may have entered Canada without status to begin with. And the scenario we're talking about here is an out-of-status woman being in relationship with a Canadian, and then experiencing abuse. So what happens to these women who don't have status and they're in a relationship, and oftentimes they will have children? How do they navigate the process? How do they leave the abusive relationship? In the focus groups that were done through the Law Foundation project, what was identified were there were actually cases of out-of-status women who had called the authorities to report the abuse, only to be referred to CBSA, who then proceeded with their removal. So CBSA is the enforcement arm of the Minister of Public Safety dealing with immigration breaches. And the fact that these women had children and may have been dealing with custody issues did not prevent the removal process. And in fact, a number of years ago, back east, there were reports of CBSA actually entering transition homes to look for out-of-status women to effect the removals. So it's very serious for these women. If they do decide to leave the relationship, they need to be guided with support of either community advocates and legal counsel, because the consequences of leaving are very severe for them, removal from the country. So they're one category of women, because the risk is so high, that are more likely to stay in their abusive relationship. And in fact, a common control tactic used by the spouse of out-of-status women, of an out-of-status woman, is to claim that the spousal application is underway. So that's saying that he's filed the paperwork to sponsor her to be a permanent resident in Canada, and inland application, and that there's some delay, and then threatening to withdraw the paperwork if the spouse decides to leave or report the abuse. And it is the fact that withdrawal of the spousal sponsorship application can, in fact, occur any time up until a decision is made. So the threats, again, are very real for these women. So how do we help them navigate through a system which is not really viewing her through a safety lens? CBSA's paramount concern is complying with their mandate, which is to deal with anyone who's breached the Immigration Act. So really the only option they have is a humanitarian and compassionate application, an H&C. And legal aid does cover these applications. Unfortunately, it has taken up to 3 to 5 years in some cases to process. I have heard more recently that the processing is occurring more quicker, in a span of maybe 6 months to a year. But in any event, even that is a lengthy time period for a woman who's got her maybe children with her, and she's going to have no supports, and it's quite difficult. So there's limited benefits to such women who are out of status and have children. There is, I think a few years back, it came into play through BC Housing. There is housing provided to out-of-status women with children, but I don't believe that's the case for out-of-status women without children. They can apply for a temporary resident permit that will give them some kind of status in the country pending the conclusion of the H&C application. Starting an H&C application doesn't prevent removals, though. Normally, immigration or CBSA will defer removals until a decision is made, and to provide the woman with some sort of relief through the process, a temporary resident permit can be sought. But again, it does take time to obtain, and it doesn't give the authority to work. So there's a lot of considerations for these women if they do leave. There's tenuous support for them. So again, it becomes a real risk for them to step out of the abusive relationship. But if they do, and they start to embark on an H&C application, then they need to turn their mind to what is the type of evidence that would help support their application. Ideally, it would be nice to have police incident reports, any documentation confirming charges were laid or convictions. But we all know that in many cases, police may not have been called, charges may not have been laid. So then we have to turn to obtaining letters of support or reports from shelters or community advocates that have been assisting the abused woman, reports from doctors, psychologists, um, to supplement the submissions and put them in affidavit form so that they are considered seriously. And some of the other factors to keep in mind when assisting a woman and making submissions on an H&C application is canvass the hardship that she would face if she was required to leave Canada. There may be customs and cultures in the woman's country of origin which may make it very difficult or impossible for her to return due to issues of honor and just shame. So she may not be able to return to her country. If she's pregnant or has children in Canada, for the best interest of the children, those need to be emphasized quite strongly. And then the degree of establishment in Canada. And that can consist of if they're going to, if the woman and if she has children are going to local community facilities, churches, organizations to obtain proof of that and to show that they're doing their best to assimilate into Canadian life. So be as comprehensive as you can in the H&C application. The slides here are a bit dated. There's a slide that I have pertaining to the law against barbaric cultural practices. This was now 2 years ago. I believe this was introduced, and it was a piece of legislation that was attempting to deal with polygamy and forced marriages and what was seen as practices incompatible with Canadian values. And one of the main reasons behind this legislation was the Shafia killings in Toronto, where a family consisting of a stepmother and 3 daughters were killed by the second wife, husband, and their son, and the rationale for the killing in the media being honor killings. So that was the reason, one of the main reasons why these laws were pushed to come into play. My own thoughts about the Shafia killings and incident are that if safety lens were on to start off with, and perhaps this incident, the Shafia killings, would not have happened. This was the stepmom, I describe her as, was actually the first wife of the husband, and she was not able to have children, so he married again, and the 3 of the girls that were killed were the second wife's daughters. The first wife was brought into Canada as a live-in caregiver or visitor. Her true status was never disclosed, and so she was obviously fearful of coming forward because she didn't have proper status. But if the lens of all these different systems that women navigate through was the same lens, safety of women, then had she come forward, even though her status was precarious, with the lens being safety, then the focus could have been on helping her out of that scenario and then helping the girls in turn. So there needs to be some reshifting in how things are viewed and how to assist women navigate the various systems. There needs to be better collaboration between the systems so that they're not operating as simple silos. One of the slides, again, is the continuation of laws against barbaric cultural practices, and it is a goal to deal with, again, polygamous forced marriages, and some of these aspects of the Act have come into play, that the age of marriage is now 16, and anyone found to be involved in a marriage where someone under that age is being asked to get married and it's viewed as a forced marriage will be viewed as a forced marriage, and they can be subject to criminal charges. So these are all new pieces. I don't know how it's going to unfold, and I'm not exactly sure how we help one navigate someone through this process because the implications of these laws are not quite known yet. In summary, the systems that women have to navigate are complex, and there's many of them that they have to navigate. When there's immigration issues involved, that system becomes even more complex. If we understand the system, then we're likely to be in a better position to help these women navigate it and keep them safe. And that's the conclusion of my slides. I end it with a slide that my daughter had picked out, and that we have to be advocates for those who can't speak for themselves. Thank you.